Hello, everyone, and welcome to Uncivil Law. For today's case, we have United States of America versus Adil Daoud. In this case, Mr. Daoud is in trouble with the United States government. He engaged in certain activities that were unfriendly to the United States and its interests and unfavorable to its agents and their interests. His activities had a certain nature to them that are more than criminal, one might say. They're not super encouraging. So in any case, he was found guilty of all this stuff, and the district court sentenced him to some amount of time in jail. And fairly unusually, because you don't see this every day, the Court of Appeals actually reverses the sentence because it wasn't long enough. They said the district court created a clear error in not giving this guy more time. It was clear error to not give him more time. That's something you don't see every day because the district courts get quite a lot of discretion. So what exactly did this guy do? And how much time did the court give him? And why is that too little? And will we agree it's too little? Let's get started with this. Daoud came to the FBI's attention after a series of online posts, communications, and search that evince a desire to engage in a violent jihad. That is the kind of thing that would get the government's attention. This online activity began as early as September 2011, the month that Daoud turned 18. In his online posts and communications that he wrote on social media for everyone to see, including the FBI, Daoud described himself as a terrorist. That'll get the FBI's attention, wrote that he wanted to die a martyr, shared songs about violent jihad, and encouraged killing and dying in the name of Allah and committing violent acts of jihad against the United States as revenge for killing Muslims. Yeah, there are many lessons here. There are many lessons here, not the least of which is, when you post things on social media, sometimes the government sees that, and sometimes the government gets concerned. Because you're saying things like, I think radical jihad would be good. I think that, committing crimes against the United States and killing the United States and people would be good. The FBI has some concerns. They have some concerns that, this might be a problem. So they're going to investigate you for, telling us on social media, I plan to commit jihad. That's kind of a clue, yes. All right, great, let's investigate. In May of 2012, to assist Daoud's threat level, 2 undercover FBI agents initiated online contact with him using fictitious identities. One of the agents posed as a 17-year-old Arab youth living in Australia. Okay. The other posed as an older Arab man living in Saudi Arabia. One of the agents contacted Daoud by email to praise a song that Daoud had posted on Yahoo Answers. Yahoo Answers is where the terrorists are going these days, okay. And described as terrorist music. The other agent initiated contact a few days later. With the agent's false interest and encouragement, Daoud began sharing jihadist materials with them. Super. When one of the agents questioned the propriety of taking lives, maybe taking lives isn't good, Daoud explained why it is good. I don't think it is good. I think it is good. Here's why. At one point, Daoud said, I want to be even worse to the Americans, the Osama bin Laden and Sheikh Anwar al-Awlaki put together. Great. I want to be a great terrorist and be a great encouragement for Muslims to do the same. Other times, though, Daoud himself questioned the propriety of terrorism. He also referenced his procrastination and laziness by saying, all I do is talk. He'd like to combine with our twin powers combined. Wonder Twins activate. So the Wonder Twins activate in this occasion are Osama bin Laden and Anwar al-Awlaki. These are the things we want to combine for the Wonder Powers activate. The FBI is less than pleased. Let's carry on. In conversations with Daoud, one of the agents referenced a fictitious cousin named Mudaffar. Hey, cousin, want to go bowling? Yeah. Who's supposedly an operational terrorist living in the United States. Eventually, the agents connected Daoud with a third undercover agent posing as the cousin. Eventually, Daoud found the perfect place for a car bomb attack. The Cactus Bar and Grill in Chicago. Okay, so apparently the place for the car bombs is the Cactus Bar and Grill in Chicago. Okay. Daoud explained that Cactus was a prime target because it was a crowded nighttime destination. Daoud and Mudaffar began planning the attack. Daoud surveilled and photographed the location and picked a site for the car bomb. He's pretty devoted to the cause, man. I wonder if he's serious. Well, he's scouting the location and taking photographs and surveilling it to figure out where exactly to put the car bomb. Seems like he might be serious. Mudaffar described the bomb that he would supply and the mass carnage it would cause. Daoud expressed pleasure with the bomb size. On the day before the planned attack, Mudaffar showed Daoud the fake 1,000-pound car bomb, which he installed in a Jeep Grand Cherokee. Jeep Cherokee, the choice of 18-year-old terrorists everywhere, I guess. Daoud said he wanted to have direct action in the attack and asked if he could press the button to detonate the bomb. To carry out the attack on the night of September the 14th, 2012, Mudaffar and Daoud met to carry out the attack. On the drive over, Daoud prayed aloud for many people to be killed. He also prayed the attack would make international news and that would not be his last operation. Once there, Daoud parked the Jeep in front of the Cactus Bar. In the nearby alley, Mahfoud told Daoud that there were 200 people in the area. Daoud responded, "This is like the lottery." Good. Shortly before pressing the button, Daoud asked if women could be killed in the United States. I guess he's concerned about killing women in this random act of terrorism. Okay. Mudaffar said yes, and then he was arrested upon pushing the button. Okay, so our 18-year-old miscreant friend over here, it seems a little bit serious about the terrorism. He's saying that he'd like to commit terrorism very much, and the FBI is now chatting with him and trying to figure out how serious he is. And he's like, I'd like to do a car bomb. I'd like to do it exactly at this location. Let me go surveil and photograph it to figure out exactly where the car bomb is. I'd like to have a direct hand in it. Can I push the detonator button, please? Okay. Yeah, and he pushes the detonator button, which of course does nothing because the whole thing was a setup, and the police arrest him. But our 18-year-old friend or a 19-year-old friend at this time probably, is not exactly done. He's not exactly done with his miscreant deeds. He'd like to commit further crimes on top of that. What further crimes? I'm so glad you asked. Let's press on. Approximately 2 months later, when Daoud was in pre-trial custody, he solicited the murder of an undercover FBI agent who had posed as Mudaffar. He won't stop. Daoud offered to pay his cellmate, a gang member, to enlist one of the gang associates to kill the undercover agent. He then gave the cellmate his agent's phone number to help track him down. Now we're trying to kill FBI agents. That's good news. Daoud's cellmate reported the offer to federal authorities and agreed to further record conversations with Daoud, so his cellmate ratted him out. So he's contacting his cellmate to help kill the FBI officer, and his cellmate rats him out to the police for a better deal. Daoud called the undercover agent a spy and suggested different ways of killing him. He has suggestions on how to kill the FBI agent. He asked that the killing be quick and untraceable. More than once, Daoud's cellmate asked Daoud if he was sure he wanted to go through with the plan. Daoud said yes. Daoud's cellmate purported to make arrangements and confirm the target by showing Daoud a photograph of the undercover agent, supposedly taken by his associates, but actually provided by the FBI. Nice. Finally, the cellmate instructed Daoud to make a phone call authorizing the killing, which Daoud actually did. When the job was done, or so Daoud thought, Daoud asked for the gory details. Daoud's cellmate asked Daoud if he regretted the decision, and Daoud said, hell no. Okay, so he's being charged with crimes of violence, murder for hire, obstruction of justice, engaging in terrorism, and is he done yet? No, he's not done yet. There's more. Okay, let's press on. In 2014, a little over 2 years after soliciting the FBI agent's murder, Daoud physically attacked a fellow inmate because the inmate drew a picture of the Prophet Muhammad. He doesn't like the photographs or pictures. How do you know it was of the Prophet Muhammad, incidentally? Did he say this is of the Prophet Muhammad? Because how would you know it's of the Prophet Muhammad otherwise? Okay, never mind. Daoud jumped on the inmate and punched him. Before his arrest, Daoud has suggested in an online post that people who drew pictures of the Prophet Muhammad should be killed. Daoud and another inmate reconciled. The inmate reconciled. They patched up. But then not so much, because in 2015, Daoud sent the same inmate to the hospital after approaching him in his sleep and stabbing him repeatedly in the throat and head using sharpened toothbrushes and a toothbrush with a razor blade attached to it. The attack ended when the cellmates intervened. So now we're going to charge you, on top of everything else, with assault with intent to commit murder, assault with a deadly weapon to do intentional bodily harm, assault resulting in bodily injury, possession of a weapon by an inmate, and assault. So our criminal record here is not looking really super good. We have engaging in terrorism. We have attempted murder for hire. We have attempted murder with the stabbing with a sharpened toothbrush and a razor blade on it. So our miscreant protagonist here has a few legal problems. So yeah. So let's see what happens next. The three criminal cases, because there were three different criminal cases from three incidents, were consolidated. So they brought them together in one trial. Great. In August of 2013, after the government gave notice of its intent to present evidence obtained under the Foreign Intelligence Surveillance Act, Dayoud moved for disclosure of the government's FISA-related materials. The district court granted Dayoud's motion in part and ordered disclosure, but the court reversed that disclosure, holding there's no basis for disclosure. So I don't know what the government was intending to produce under the Foreign Intelligence Surveillance Act. I don't know what the deal with the underlying things are, but normally for FISA, you're only talking about criminal warrants. You're only talking about warrants to gather information. But apparently they wanted to present information. He wanted other information. The court said no, which, because it's just materials to get a warrant. How they got the warrant is not quite as interesting as the things that happened once they got the warrant. The many conversations with the FBI and the picking the spot for the car bomb and detonating the car bomb, or at least you thought, and then trying to kill the FBI agent and then stabbing a guy with a sharpened toothbrush and some razor blades. Now, how they got the warrant is not the most interesting aspect at this particular point. The court scheduled the trial for November the 26th of 2018. On the day before the trial, Dayoud moved to plead guilty while maintaining his innocence, pursuant to Alfred, which we covered recently. The court granted his motion over the government's objection. The government said, we don't want him to plead to an Alfred. And the court said, what do we care? It's a guilty plea. If he wants to maintain his innocence, whatever. So fine. Dayoud pled guilty to all the counts, admitting the government's evidence supported the conviction on every count, but denying culpability and persisting in his innocence. He says, I didn't really do all those things. I feel like the government might have some evidence that you did those things. Okay. So now that we know what he has been charged with, or what he's actually pled guilty to, so what he's been convicted of, so we don't even have to say hypothetically because it happened, he's been convicted of those things because he pled guilty to those things. So he pled guilty of conspiracy to detonate a weapon of mass destruction. He pled guilty to attempted hired murder. He pled guilty to attempted murder on his own, and some other things. So a couple criminal violations. So now, what did the district court actually sentence him to? Okay, the parties agree the advisory guidelines for this particular offense or offenses is life imprisonment. So the advisory guidelines say, how about life? Which seems, for attempted use of a weapon of mass destruction, seems like probably correct without me looking it up. The government, however, recommended 40 years, stressing the predisposition to commit acts of terrorism, the seriousness of his three interrelated crimes, and the sentences imposed in serious other cases. So the government actually wants to give him a break and only put him in jail for 40 years. Not sure why the government thought that was a good idea, but that's what they said. Dayoud, however, asked for only 9 years imprisonment. Dayoud thinks that the attempted weapon of mass destruction and the conspiracy and the attempted murder and the murder for hire only warrant 9 years in jail. Okay. And he also wants credit for the 7 years he's already served. He only wants to be in jail for 2 more additional years, please. That seems good. He stressed his age, mental health issues, harsh conditions of the pretrial confinement, his susceptibility to influence, and the government's imperfect entrapment. It doesn't sound like the government entrapped you in any reasonable sense. We'll get to this in a second on the definition of entrapment, but whatever. Without the FBI's involvement, he argued, Dayoud would have lacked the ability to drive and attempt to do the mass terrorism, and the prohibition officer recommended 15 years. Okay, so we have to have a brief discussion about what is and is not entrapment. All right, so something is entrapment when the government gets you to do something you wouldn't otherwise do, is your short definition of entrapment. It's obviously more complicated than that. But the short definition of entrapment is the government gets you to do a thing you wouldn't otherwise do. The government is the one getting you to do it, okay? If you are the one saying, I want to commit mass acts of terrorism, and I would like to blow up a place, and let me do the surveillance, and let me do the thing, and let me push the button, that is not exactly entrapment. The FBI, apparently they gave you many opportunities to bail out, and you said, no, I want to persist on, please. And then it's also not entrapment when you say to your prison inmate, or you say to your cell inmate, I'd like to kill the FBI agent who did all this, and he rats you out to the FBI. That is also not entrapment. Is also not entrapment when you stab a guy with a sharpened toothbrush for drawing pictures. None of these things are entrapment. We're not even close to entrapment. Entrapment is where the government gets you to do things you wouldn't otherwise do. It seems like you are more than willing to do all these things. The government may have helped in some ways, but it wasn't like you didn't want to do it. You seemed more than eager to do it. So him saying imperfect entrapment is like, no, this is nothing even remotely resembling entrapment. You were all about this without the FBI being involved. This is not entrapment. No. Daoud presented his allocution during his plea. He told the court, I can't express how sorry I am for my actions. Upon reflection, Daoud concluded that he had been naive, gullible, and confused in his beliefs about fighting for Islam. Okay? He attributed those views to misinterpretations about the teaching of Islam. With respect to the bomb plot, he stated that he should have been more assertive with Mudaffar. I learned that I have to make my own decisions and not let someone else make them for me. Seems like you made plenty of decisions on your own to me. Still, he apologized for whatever part I took place in the events, such as pressing the detonator button. That would be the part you took place in. Pressing the button to detonate the bomb. Like that. He disavowed any intent to engage in terrorism, you know? Kind of feel like there was some intent to engage in terrorism. I don't want to kill people or join a terrorist group when it's something condoned by my religion or not. Doesn't feel like that's really what you were thinking before earlier. The court sentenced Daoud to a total of 192 months, 16 years in prison. So the attempted use, okay, so the attempted use and conspiracy to commit terrorism and use a weapon of mass destruction, the attempted murder for hire, and the attempted murder with the stabbing, all those things together, the district court says, how about 16 years? How about 16 years for the attempted terrorism, attempted weapon of mass destruction, attempted murder for hire, attempted murder with the stabbing? How about 16 years? I don't know, man. Seems a little thin. The breakdown for this term was as follows. 192 months for both counts in the attempted bombing case to run concurrently. 16 years for the attempted bombing. Okay. 120 months on counts 1 and 2, and 140 months on count 3 in the solicitation case. That would be the attempted murder for hire. All to run concurrently with each other and the other sentences concurrently, even though they are distinct crimes. So normally they'd be consecutive because they're distinct. But for some reason we're doing it concurrently. Okay. 120 months for counts 1 through 3, 16 months on count 4, and 12 months on count 5 in the assault case, which, that would be the attempted murder. All to run concurrently. Again, normally this is consecutive. All right. If you want the cheap and easy definition for when something should be consecutive versus concurrent. So should they all run at the same time or should they run at different times? The cheap and easy rule is things should be concurrent. They should all happen at the same time if the underlying crimes are all concurrent, right? So if they all happen as part of what's sometimes called a common criminal transaction, right? Are they all part of the same enterprise and scheme? So as a typical rule, again, your mileage may vary substantially, but as a typical rule, if they're all part of the same criminal transaction, then the sentences don't stack. However, if they're part of distinct criminal transactions, they do stack. So one would imagine that these are distinct criminal transactions. The attempted bomb plot has very little to do with the attempted murder solicitation, has very little to do with the actual attempted murder. But for some reason, the court says, how about we run them consecutively so it all counts as one big pile and you get 16 years? The court described the bomb plot as a violent and heinous act to kill or harm others, the seriousness of which cannot be understated or downplayed. I don't know, it feels like you might be understating or downplaying it right about now. Such an attempt clearly deserves the possibility of a prolonged sentence, including life in prison. Similarly, on the solicitation offense, which remind you is solicitation for murder for hire, the court remarked that any attempt to harm law enforcement for doing their job must be addressed with serious consequences. Turning to the inmate assault, the court notes that the harm caused the inmate was serious and violent. Yeah. In short, these crimes the defendant has pled guilty to are all serious and deserve serious sentences. With respect to the solicitation offense, which again is for the murder for hire, the court stressed that Daoud was sharing a cell with a multiple convicted gangbanger who verbally abused him. I'm not sure why that would lead him to try to kill the FBI agent as opposed to his inmate, but whatever. Similarly, Daoud admitted to the following through on some of the steps directed by the cellmate that support the conviction and sentence for deterrence. Cellmate banter should not outweigh the seriousness of threats of life and law enforcement. Prior to the inmate assault, the court noted that Daoud had been in restrictive confinement for more than 1 year. May need more restrictive confinement, may need more. Before finally imposing its sentence, the district court addressed the parties' sentencing recommendations. It stressed the cases cited by the parties in support of their recommendations were distinguishable on one very important point the court is going to rely on, and that is since the lengthy detention Daoud has endured ever since he was first detained at the age of 18. So the district court says there are a whole bunch of cases that you guys have cited as to sentencing, but there's one thing here that's not common in any of those cases. The fact that he served lengthy detention. Okay, why does that matter? Why does that matter? Yes, he's served lengthy detention at this time for crimes he's not yet been convicted of, and he'll definitely get credit for it. But, why is that a problem? That he served this detention. It's time that he's supposed to serve from the crimes. But apparently that's different for some reason. At its sentencing hearing, the district court wrote the following. This sentence addresses the safety of Americans in the future of Abdul Daoud, who spent his entire adulthood in the Bureau of Prisons, including more than a year in the Special Housing Unit, also known as the SHU, also known as solitary confinement. Daoud committed 3 violent or potentially violent offenses born out of immaturity, bad judgment, and problems of growing up in an intensely anti-Muslim environment where violence against Muslims is referred to directly or indirectly as Americans. It's immaturity. Okay, the federal undercover employees sympathized with Daoud's angst and encouraged his feelings, as you do in a, investigation. Most of all, the agent was a friend who had no friends. The line between teenage awkwardness and zealously violent jihad can be gray, but clearly this young man might have been susceptible to a much less violent method of revolution if it had been presented instead of the 1,000-pound bomb. It was the dirty, dirty FBI for making the 1,000-pound bomb available. Okay. During his time in federal custody, he's also witnessed a cellmate suicide, been cellmates with truly hardened and abusive prisoners, and been taunted by others about his religion and faith while being separated from his close family for 7 years. Why was he separated from his close family for 7 years? Oh, that's right. The terrorism. During this incarceration, he is mentally deteriorated, requiring constant psychotropic drugs, and violent outbursts are no responsiveness. Daoud entered prison barely 18 and won't leave until his mid-30s. While I feel satiated, supervised release for 45 years of monitoring should address the safety of the public with possibility of salvaging the life of this young man. The government appeals the district court sentence as substantively unreasonable. Well, I do believe in my heart. That justice should and must be tempered with mercy. I believe mercy is a good thing. And I believe justice should and must be tempered with mercy. And I believe that there are times, perhaps that are undefined and cannot be defined in advance, where justice does need to bend to other considerations. Strict applications of justice can be a problem. All that being said, however, I do not personally feel like this is one of those times. Whatever the merits may be, occasionally maybe justice is imperfect and maybe mercy should rule the day. I'm not really sure that I'm feeling particularly merciful on this particular occasion with the, attempted car bomb, weapon of mass destruction, conspiracy to commit terrorism, conspiracy to solicit murder for hire, attempted murder with the stabbing. Not really feeling that whatever the merits might be of justice must be tempered with mercy. Not feeling the mercy equation of that side, particularly today. There might be a time and place. Not sure this was it. Okay. District courts must impose sentences that are sufficient, but not greater than necessary to comply with the basic aims of sentencing. To do this, you must consider the factors as set up for in the statute. The nature and circumstances of the offense, the history and characteristics of the offense, the need for the sentence to reflect the seriousness of the offense, to promote the respect for rule of law, provide for just punishment, deter crime, protect the public, and provide the defendant with training, medical care, or other correctional treatment, the kinds of sentences available, the United States Sentencing Commission's recommended sentencing ranges and policy statements, the need to avoid unwarranted sentencing disparities among similar defendants and the need for victim restitution. We review the substantive reasonableness of the district court sentence under abuse of discretion, which is normally really, really, really hard. For a court of appeals to reverse a lower court for abuse of discretion requires quite a lot. Will they find it in this case? Let's press on. For several reasons, the district court sentence in this case fell outside the range of reasonable sentences. First, the court downplayed the seriousness of Daoud's offenses in ways that conflict with the undisputed facts. Second, the court failed to account for the need to protect the public from Daoud's demonstrably high risk of reoffending. Third, the court improperly distinguished the sentence of similar offenders by relying on the long period of pretrial confinement, which doesn't even begin to matter. Why'd you bring it up? Finally, the court premised its well below guideline sentence on mitigating factors that could not bear on the heavy weight it assigned to them, given the facts in this case. Yet the court went on to effectively negate these statements and the severity of the crimes by characterizing the crimes as merely misguided actions of an impressible teenager who let others get the best of him. The court portrayed Daoud as awkward and immature, with few friends, who's trying to impress his false friends, the undercover FBI agents, trying to impress them with the car bombing. You know, of many ways to win friends and influence people, might I humbly suggest the car bombing is not one of them. It credited Daoud's argument that he lacked the capacity to carry out the terrorist attack by himself, thus minimizing his agency in the plot, agency that was reflected by him picking the time, place, and manner, him surveilling, and him pushing the button. There's some agency there. The district court blamed the inmate assault on Daoud's mental health issues and conditions of jail, which make false physical altercations inevitable, while allowing that Daoud's inability to control himself where someone is not physically attacking him deserves punishment. More broadly, the district court framed Daoud's risk of reoffending as a risk that he be co-opted or persuaded again, because he was merely duped. He had no thoughts of his own. These sanitized accounts are impossible to square with the undisputed offense conduct and objective seriousness, the violent nature of the crimes to which they pled guilty. Daoud committed 3 discrete, premeditated criminal acts that exhibited extraordinary disregard for human life. He took an active role in the bomb plot, helping to plan it over the course of months and then asking to press the button to detonate the bomb that he anticipated would kill hundreds of people and receive national attention. Yeah, he had countless opportunities to back out, yet he continuously reaffirmed his commitment. Next, Daoud solicited the murder of the FBI agent who acted in an undercover capacity in the bomb plot. Not only did he solicit it, he made the phone call authorizing it, and he expressed satisfaction, asking for gruesome details, and disclaimed any regret when he thought it was over. Finally, Daoud brutally attacked his fellow inmate with makeshift weapons while he was sleeping. He stabbed him repeatedly in the throat and head. The inmate testified that he thought he would die, absent quick intervention. The district court's view of this crime, embodied in his comment that Daoud's inability to control himself when someone is not physically attacking him deserves punishment, reflects a misunderstanding of severity. The Court of Appeals feels that you might be underselling it a little bit. The Court of Appeals feels that the way you phrased it may not be completely accurate. He had an inability to control himself when someone is not physically attacking him. It's not exactly the most correct way of characterizing exactly what happened. Daoud simply did not fail to control himself. He planned and executed a deliberate attempt at murder of a fellow inmate in his sleep. In short, while the district court played lip service to the seriousness of the offense, it undercut its own statements by unreasonably underplaying his role in each offense. It kind of had a little bit of something to do with the attempted weapon of mass destruction, terrorism, conspiracy, attempted murder for hire, attempted murder, stabbing. Kind of had something to do with those things, a little bit, yeah. The law instructs district courts to consider the need to avoid unwarranted sentences disparities among defendants with similar records who've been found guilty of similar conduct. Equal protection is a good goal. Here, both parties brought sentences of similar offenses to the district court's attention, but the court found them all to be distinguishable, largely because Daoud's lengthy pre-trial detention. That is a legal error. No matter what sentence he does receive, he will receive credit for his time for the charged offenses. So, yeah, he might have served a lengthy pre-trial detention, but he gets credit for all that time, so why does it matter? It doesn't. Daoud's 16-year sentence was a significant downward departure from the advisory guidelines. Whereas the guidelines recommend life imprisonment, the court sentence would have released Daoud from prison around his 35th birthday. And then the court notes that doesn't even take into consideration the possibility of good time credit, which would allow him out even earlier than that. Because under good time rules, you would have to serve 80% of your sentence. A major departure from the lines requires a major justification. The district court spent most of its time discussing the mitigation, but the factors do not justify this significant downward departure. In the district court's telling, his age, mental health, and general awkwardness and impressionability converge to render him uniquely susceptible to criminal influence, such as the attempted mass bombing. A sentencing court is well within its rights to consider a defendant's mental limitations and mitigation, but that factor only goes so far. Daoud committed the attempted bombing around his 19th birthday. He was 19 when he solicited the murder and 21 when he tried to stab someone to death. For his part, Daoud defends the sentence because it was higher than the recommended sentence of 15 years and because it included 45 years of supervised release. But probation sentencing recommendations only are informative. They do not bind a judge or otherwise limit discretion. So probation's recommendations are super duper interesting and all, but they don't really matter in the end because they are recommendations. We do not call into question a district court's broad discretion in fashioning sentences. District courts are best situated to develop sentences that fit facts to crime and characteristics of the defendants. We substantively review sentences only to ensure they fall within a wide range of options that are reasonable under the circumstances. We find this is one of those rare cases where the district court stepped out of line with what was permissible. Accordingly, we vacate the district sentence and we remand for resentencing. Thus, that brings us to the end of the discussion of United States of America versus Abdul Daoud. In this case, Mr. Daoud apparently was merely a lost youth who I don't know, was particularly susceptible or something. Susceptible to the point that he thought, he said jihad would be good, and he came up with the car bomb and picked the place and time and manner and pressed the button, and also solicited the death of the FBI agent and also stabbed someone to death. But he's a good boy who ain't done nothing wrong or something. The district court gave him 16 years, and the Court of Appeals says, the district court gets a wide amount of latitude, but not infinite latitude. And so we think that they abuse discretion. So we're going to send this back for resentencing, perhaps maybe take it a little bit more seriously, but at least for the moment, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.